Welcome everyone to the 93rd Informal Discussion Group session with Mr. J. Sai Deepak. Mr. J. Sai Deepak is an engineer turned litigator who practices at the Delhi High Court and the Supreme Court of India. He is well known for having represented the interests of the deity in the case of Young India Lawyers Association versus State of Kerala. He is also an author and authors a column regularly for the Sunday Guardian Live and for other reputed magazines and journals. The topic for today's session is Civilizational Tenets of the Indian Constitution. Our moderator for today is Professor Shamik Sen, who is the Professor of Constitutional Law and Media Law at NUJS. I now hand over to Shamik sir to take over the proceedings from you.
Thank you. I think, to the audience here, Mr. J. Sai Deepak needs no introduction. You have all read him, you have heard him extensively, during the Sabarimala hearings. His views on the NRC and the CAA, which were widely circulated, on the social media as well. A lot of people were referring to it, a lot of people were sharing it. So I'm sure you have already have, sufficient amount of knowledge as to Mr. J. Sai Deepak and his works. So there's no point introducing him or reintroducing him to this audience. But what is interesting is his topic that he has for this evening, Civilizational Tenets of the Indian Constitution. When the IDG offered me to moderate this session, the very first impression that I had, the very first reaction that I had was that I have seen advocates, I've also seen devil's advocates, I've never seen a deity's advocate. So Mr. J. Sai Deepak, fits into that extremely, rare category of lawyers. And I'm sure a lot of what he's going to say today on the civilizational tenets of the Indian Constitution also have this underlying, his idea of what the Indian ethos is and how the Indian ethos is different from the constitutional ethos of the other countries which we tend to always follow. So I'm sure he's going to touch upon those issues, and I'll be extremely, extremely interested in hearing him and his views on all these issues. It's just that there is a housekeeping rule in order. The speaker has made it very clear that he wants his initial presentation to be short. He wants questions to come in, and the conversation can flow with the questions. So while you ask him questions, definitely he's ready to answer all questions that you ask him. Yeah, but please type your questions on the chat box such that I pick up those questions and convey them to him, right? And on the chat box, please ensure that you are only asking questions. General introductions, general comments. Try to avoid them as much as possible. Questions will be more appropriate, right? So on that note, let me invite Mr. J. Sai Deepak for his initial presentation.
Thank you, Professor Shamik, and thank you to the organizers, especially the members of the informal discussion group, for having taken the pains to accommodate me on this platform. I'm very, very happy to address the enlightened students of one of the best law schools in this country, premier law schools in this country, NUJS. In fact, I think I've had the opportunity to visit your campus twice. One was when I met Professor Shamnath Bashir for the very first time, while I was still part of SPY CIP. I think this was in 2008. And I think the second time I'd come for some lecture or something, or maybe I attended a lecture. I never delivered a lecture at NUJS, of course. So I'm very happy to be amidst you, of course, virtually. 2 or 3 clarifications just to add to the housekeeping rules of Professor Sen, because typically, I don't know whether it's me or my topic or the issues that I choose, that I end up getting a lot of provocative questions, which I thoroughly relish and enjoy. So my only request would be that please go ahead and ask whatever you think is relevant to the topic. And even if it is sharp or provocative, I don't mind. The only request would be that kindly observe civility in the tone of your questions, because by nature, I'm someone who responds and gives it back if somebody crosses a line. That is something that I'd like to make very, very clear, because that's my style and that's how I operate. Second, as far as my basic position is concerned, let me sum it up in as crisp a manner as possible so that I open it up for questions. One, I believe that the Constitution is not strictly or militantly secular document as it has been made out to be. It has its own identity-related positions, which perhaps we have scuttled and brushed under the carpet. That's point number one. And there are enough and more, let's say, pointers to support this particular premise or this particular position, not just from within the Constitution, but also from the surrounding documents, so to speak, which have led to the preparation and the drafting of the Constitution, coupled with also with statements made by leading members of the Constituent Assembly. But of course, the statement of one particular leading member or even a host of leading members doesn't translate to a position of the Constitution itself. Now, applying that logic, therefore, Dr. Ambedkar's position cannot be reflective of the Constituent Assembly's position or the Constitution's position, because he was just but one of the members of the Constituent Assembly. He may have been a chairman or the chairman of the drafting committee, but he himself was representing quite a few positions and quite a few views that had come as part of the stakeholdership, let's say, which was undertaken after the draft constitution was made available in public domain. And multiple opinions were sought, I think, from February 1948 to perhaps even October 1948, rather November 1948. So therefore, my position is that as opposed to treating this particular book or this document as the product of a solo act, and as opposed to treating this as a document which has got nothing to do with history, which would be a completely ahistoric position, the document must be read in the context of its history. That doesn't mean that you ossify it and you cast it in stone. It is capable of a fair amount of malleability and flexibility, but regard must be had to the history, even when you seek to stretch it to apply to any contemporary situations or circumstances. That's point number two. Point number three is assume for a moment that the Constitution is not a civilizational document. This is an alternative position. It is my case that the Constitution must be interpreted in a manner which is consistent with civilizational ethos. And what are civilizational ethos? As in when people ask me sharp questions and pointed questions, I will respond to that, because I have identified these positions as part of my ongoing series under the column Indic Views in the Daily Guardian, where I've been writing on this particular issue. And the idea has been to move out of these strict, watertight, mutually destructive and exclusive compartments, such as left and right, which I'm sick and tired of practically, because I don't think it really serves a purpose. And to apply the left and right boxes to the Indian circumstances is anachronistic, and I don't think we really fit in those boxes in any manner. Neither are we truly left, nor are we truly right. Nor is the left truly left, nor is the right truly right. And I don't think there's a concept of a proper right in this country. So therefore, according to me, it's time to move out of these boxes and try and look at this particular document in perhaps a different light, if possible. If someone asks me what gives you the right to say that this particular document is a civilizational document, then I would have to hurl the question back, which is, what gives you the right to say that the document is a feminist document? What is your basis to make this particular conclusion? If you arrive at a certain conclusion based on your positions, then I have a right equally to arrive at my conclusion based on my positions. But the good part is at least my positions are supported by the history of the document. And there is enough and more surrounding the preparation of this particular document that lends support to my position. And it's my very clear belief that the document is not supposed to be read only along with the debates of the Constituent Assembly. You're supposed to go much beyond that, which means everything that started from the junking of the Home Rule movement in 1889, and from there moving to the concept of Purna Swaraj, and from the movement from, let's say, the Dominion status to complete independence, what triggered it, what were the discussions, and how ultimately the narrative surrounding the preparation of the Constitution itself started taking a very indigenous and a civilizational shape, coupled with the fact that the case for the Constitution and the case for Indian independence was not just made by political leaders, but was also made by a host of historians who actually started writing in support of the concept of India as a civilizational state in order to make the case for Bharat's independence. So when you look at this particular history, or when you look at this particular document, it is inevitable, indispensable, according to me, to read the document along with not just historical developments, but also with reference to specific points of history and specific historical works, which have a very clear bearing on the manner in which this particular country was given its name Bharat as part of Article 1. And coupled with the discussions, the specific discussions on at least two dates, perhaps I think the 17th of September 1948 and 18th of September 1948, where there was a significant amount of discussion surrounding the adoption of the name Bharat as an alias for India. What led to it? What were the documents referred to it? What was the history? behind it and what was the significance and importance behind it. Makes a lot of, let's say, it gives us a lot of food for thought and supports the fundamental argument that it is a civilizational document and therefore must be read from an a-colonial lens and a decolonial lens as much as possible, which is not to say that you treat this document as having a xenophobic character, nor should you use that effectively to perpetuate xenophobia. But there is no point in saying that the document says that Bharat does not have a religious identity. It does not mean it doesn't have a historic identity, nor does it have a civilizational identity. I think it's important to be able to parse each of these strands and each of these layers of nuance as much as possible. Because if you don't do that, then you're effectively operating in a vacuum, as if this particular document has no sense of self, has no sense of consciousness, has no sense of identity, which is far from the truth and has absolutely no basis given the backdrop in which this particular document was crafted and drafted. Now you can start with the questions.
Before I ask the participants to ask questions, I just have a couple of questions. I'm abusing my privilege as a moderator and asking the first few questions.
Please.
If that is okay with you.
Yeah.
I was very curious, when you had argued the right of the deity in Sabrimala.
Yes, please.
I was very curious as to, how you'd circumvent the subject to public order, morality, health, and other provisions of this part, opening sentence of Article 25.
Right. Okay. So would that mean that you accept the premise that the deity otherwise has rights under Article 25(1)? Are you taking that as the accepted premise?
No, I'm just going by your argument. So if your argument is that the deity has rights, now
right,
how would you circumvent the other provisions of this part?
No, so let me, would you have the Constitution, especially Article 25 in front of you? Let's do perhaps a clinical reading of it, if that's okay with you.
Yep, absolutely.
Yeah, okay. So in order for me to be able to cross the threshold, or let's say, let me apply the contingent clause, which is subject to public order, morality, and health, and the other provisions of this part. The first premise is that the subject to clause applies to a right which exists and whose existence is recognized. Because it says that subject to public order, morality, and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. So assume for a moment that I don't qualify as a person who's entitled to a right which is specifically recognized as part of Article 25(1). There is no question and there is no need for me to address the question of the contingent clause, right? Absolutely. So there are two aspects to this argument. One, I must effectively prove that I am a person and I need not be a citizen for the purposes of Article 25. Second, I need to prove that the right which is being asserted is the right which is specifically referred to here, which is the freedom of conscience and the right to freely profess, practice, and propagate religion. Three, assuming that these two parameters are satisfied and these two ingredients are ticked, the next question would be, how do I balance the assertion of my right with respect to my abode as the deity and as the owner of my abode against the requirements of public order, morality, and health and other provisions of this part, right?
Yep.
So would you mind if I satisfy the first two requirements and then proceed to answer the third requirement?
Sure.
Yeah.
Up to you.
Okay. So the entire argument was based on at least three existing judgments, one of the Privy Council and two of the judgments of the Supreme Court, all delivered in the context of either property, endowment-related litigation, or let's say tax-related litigation, which is to basically say that for all practical purposes, when it comes to a Hindu religious institution, you treat the deity as the owner of the property and the litigation is fought in the name of or is defended in the name of the deity. That is the fact. And this particular jurisprudence is not something that has been specifically evolved post-independence, but this is how charitable endowment-related litigations have been addressed, even by Privy Councils and British judges, so to speak, pursuant to their principles of autochthonous application of common law principles to local customs, which is to say, if there is a specific principle of property law or if there is a specific principle of legal fiction that is recognized under English law, you try and see how you can tailor those principles in accordance with the institution or the community which is the subject of litigation. Therefore, the question simply was, Whether or not I recognize the concept of a deity under English law or Roman principles, the basic question is, do I recognize the concept of a pious purpose, which is at the heart and let's say which is the pith and marrow of every endowment, every religious or charitable endowment. Therefore, a specific purpose needs to be identified to which that particular property is dedicated or endowed. Now, in this case, the deity translates to, for all practical purposes, the pious purpose under English or Roman principles. But of course, if you were to apply Hindu law, he or she effectively becomes a living person, because the ritual is not just a ritual for the purposes of, let's say, sanctification or consecration, but that ritual gives rise to a legal fiction, which is to say you've invited a specific energy in the form of a deity to inhabit a certain place, and that particular deity takes the shape of the murti, and therefore that murti becomes the personification of your pious purpose. And that personification need not be a natural person, it can be a juristic person. Therefore, the simple argument was, one, if you're willing to recognize the personification of a company for the purposes of Article 25, or for the purposes of Article 819, or for the purposes of Article 14, or for the purposes of Article 21, because the right to privacy, which is part of right to life, is not just enjoyed by natural persons, it is equally capable of being enjoyed by companies as well, which is one of the issues that was discussed as part of the right to privacy judgment. Now, therefore, the basic argument would be, one, personification of inanimate objects or persons is recognized. That is also specifically endorsed by 6 out of 9 judges in the State Trading Corporation judgment, including Justice Hidayatullah, who writes a separate opinion in that particular judgment. Therefore, the question is, if rights under 14 and 21 are capable of being enjoyed by non-natural persons, what stops a deity in the context of Article 25(1), which speaks of religion, from enjoying similar constitutionally recognized fundamental rights? Okay, that's point number 2. Point number 3 from there would be to understand the character of the institution itself. If the temple is treated not as a place of prayer, but as a place of worship, and there are at least 7 judgments of the Supreme Court where the concepts of consecration and desecration in the context of a temple have been recognized, and coupled with the Ismail Farooqi judgment, where the court clearly strikes a distinction between the nature of a mosque and the nature of a temple, and clearly says that as far as the temple is concerned, it's a place of worship because a specific deity has been invited to settle there or inhabit there. Then you recognize the concept that the temple is, notwithstanding its public or private character, is primarily the abode of the deity to whom it is dedicated in the first place. Okay. So once you recognize that, then you ask yourself the simple question that if the deity resides in a certain abode and the temple is seen as its abode, are we then going to say that the deity does not have the right to lay down the principles or the rules that shall be observed in his or her abode? Now the question will be, how do you strike a balance between the rules which the deity prescribes for his or her abode and balance it against the requirement of the Constitution, which is to say that such rights shall be enjoyed only subject to public order, public morality, and public health. And therefore, morality and health are not to be read in isolation. They would be public order, public morality, and public health. The word public extends itself not just to order, but to morality and health as well. Okay. So there the argument would be that you ask yourself whether the rule has been specifically laid out to protect the sanctity of a certain institution, which is consistent with the nature of the deity to whom that institution is dedicated, or is the rule premised on a fundamental disdain for, a fundamental disgust for somebody's caste or somebody's birth or somebody's gender? Okay. So there, assuming for a moment, what is the test of arbitrariness, that there is no rhyme or reason, that it seems all arbitrary and it seems like a cooked up, concocted, manufactured rule to specifically keep out a group from that particular institution. Therefore, if there is a deity who has a specific character and there is a rule that appears, at least on the face of it, to be consistent with that particular character, even if the observance of that rule translates to exclusion of certain people from gaining access to that particular place, it still translates to a justified balance having been struck between the rights of the deity to preserve the sanctity of his or her abode and the right of other enjoyers of 25(1) to have access to that place. Most importantly, I think we have to also consider that a devotee, so there are three sets of people: one who wants to enter at the expense of the rule, one who doesn't want to enter to observe the rule, one who is the fount of that rule and who's also a practitioner, let's say practitioner of his or her dharma. So the founder of a particular institution or the founder of a particular religious denomination or even a way or a path or a panth, so to speak, is the first practitioner of 25-1 as far as that particular path is concerned. Okay. And therefore, everybody else who wants to enter that particular place is subject to his or her wishes or edicts. Now, the reason why 25-1 even exists is to ensure that no particular individual gets to enter a particular religious institution at the expense of the rights of everybody else, especially the rights of the deity to whom that institution is dedicated. Therefore, if at all there is a pecking order of rights in which, let's say, you have to create a hierarchy or a pyramid of rights, then the person who wishes to assert a right under Article 25(1) at the expense of the tradition of the temple is the person who is last, who ranks absolutely at the fag end of it. Because that person claims to believe as well as challenge the tradition of that particular temple. Now, assuming that one applies the, let's say, the essential religious practices test, which of course I don't believe in anymore, even then, if it is established that something is so fundamental, the rule is so fundamental that it informs and influences the character and the identity of the particular institution, then I would say the 25(1) of that particular individual who's asking for the non-observance of the particular rule will effectively have to give way to the rights of other devotees as well as the rights of the deity itself. However, if it is established that what is being observed practically has got no relation to the character of the particular institution, does not inform the character of the deity in any manner, does not inform the form of the deity in any manner, and has no bearing on the nature of the institution or its history at all, then it is capable of being chunked. However, the question will be, is it for the judiciary to undertake that particular analysis as to what forms part of a religion, what is superstition, what is not? Is that something which was envisaged for an analysis under 25(1), or was it limited to 25(2)(a) within the Shirurma judgment of 1954, where secular was interpreted in the context of 25(2) and not 25(1)? Then the question effectively comes about as to how can the judiciary sit in judgment on a religious practice, and is it not for the society and the state to arrive at a social contract as to what constitutes a reform for the purposes of 25(2)(b), in order for certain rights to make way for, let's say, the concept of social justice or gender justice or caste justice or whatever it may be. Okay, so
right.
To me, all three limbs are satisfied in the context of the deity's rights.
Okay, thank you. I just had a couple of questions, just to follow it up.
Yeah.
Because you brought up the question of 25(2)(b.
Yes.
I just wanted to ask you, so this is my first question and there'll be a second question and I'll end there. So I'll leave the floor open to others.
Take as long as you need.
So since you brought up the point of 25(2)(b,
yeah.
Now, I was curious as to why are you looking at the rights of the women who want to visit Sabrimala as an exercise of that 25(1) and not an exercise of 25(2)(b, where you are allowing, Hindus from all, sections to, enter the temple.
Brilliant.
So that is question number one.
Right.
And question number two is that, when you were, saying that, I understand that Ismail Farooqi does make a distinction between a mosque and a temple, but that aside, when you were saying that the deity of a shrine can, basically prescribe the governing rules, then would you say that the same argument would apply to the Haji Ali?
Of course, without a doubt. Of course.
Okay.
So in fact, I would say, so let me address the first question. Now kindly take a look at 25(2) along with B.
Yep.
Okay. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law for the purposes of public reform or whatever it may be. The judiciary has no business under 25(2).
Right.
Okay. That's point number 2. Now, second, in order for you to establish that something mandates, requires, warrants, or merits reform, you have to establish the problem statement. Okay. Now, so I come from a mechanical engineering background. Of course, it's been about 14 years since I abandoned that avatar. But whenever, let's say, you have to arrive at a certain solution for a problem, there is a specific flowchart called the Euler's design. Euler being spelled as EULER. So what you first do is you identify the problem statement. and you elucidate the problem statement as to why you believe that something merits certain attention. What is the challenge that it poses? Okay. Now, if someone says that the need for reform is because I am not allowed inside that particular institution, then the rule itself is being touted or is being presented as the problem. Therefore, the argument is being presented to the effect of saying, and it is reduced to the effect of saying, that every rule which has the effect of keeping certain people out of certain rituals or certain institutions for the purposes of preservation of sanctity of a certain instance is necessarily a problem which requires a reformist approach, a reformative approach, then we might as well do away with all rules and all rights and all rituals, which organizations and institutions, whether or not they're denominations within the meaning of Article 26, have the right to protect it under Article 25(1). And if they happen to be denominational institutions, they have even better rights to protect it under Article 26(b). Now, the standard strawman that I get whenever I make this point is, would you then have justified untouchability? And the entry of, let's say, and would you have effectively justified the very same argument, or use the same argument to prevent the entry of the hitherto untouchables into temples? Okay. There are two answers to this. One, the problem is the Article 25(2)(b) itself answers that question, wherein it is the legislature or the parliament which has taken a position with respect to entry, and it's not the judiciary that has taken that particular position. Okay. Where it says that and reform or the throwing open of Hindu religious institutions or of public character to all classes and sections of Hindus. Okay. So one, it is the legislature that takes a position. Second, having taken this position under 25(2)(b), it also takes a position with respect to 26(b), wherein 26(b) specifically allows a religious denomination to manage its own affairs and matters of religion. Therefore, the question would be, when the state chooses to pass a law, it has to strike a balance between what it claims as a decision taken in the interest of public for social welfare or for reform, within the meaning of 25(2)(b), and how does it choose to strike a balance against the rights of a denomination under 26(b), or even if that institution is not a denominational institution for the purposes of Article 26, how do you strike a balance between 25(1) and 25(2)(b)? Okay. Now, each of these tests is to be applied in the specific context of the institution, its history, and after asking yourself whether the practice is fundamentally discriminatory, whether the rule is fundamentally discriminatory. Therefore, it boils down to the simple test of what constitutes discrimination. And therefore, the question will be, is all exclusion discrimination? Are all rules which keep certain people out of the institution or from certain rituals discrimination? In which case, if it is ultimately the rule, perhaps in most southern temples, that no one other than the priest, whether he is a Brahmin or a non-Brahmin, whether the priest is a Brahmin or a non-Brahmin, or whether the devotee is a Brahmin or a non-Brahmin, can ever enter the sanctum sanctorum and touch the deity's idol or the icon or the murti itself. Tomorrow, the slippery slope would be that this would be treated as something which is problematic because it doesn't further the cause of equality, egalitarianism, social justice. And therefore, every rule that is observed to preserve the sanctity of the deity and its sanctum sanctorum will also be wiped away, washed away, and cycloned away, according to me. Therefore, nothing remains of rights under 25(1) or 26. If ultimately the argument is anything and everything that leads to exclusion of a certain set of people is necessarily discrimination, that is not the test of discrimination. If there is a reason, then it is selection. If there's a reason, it is intelligible criteria. If there's a reason, then it automatically removes the scope of arbitrariness. Now, answering the second limb of your question, what about Haji Ali Dargah? As far as Haji Ali Dargah is concerned, I have a problem with the judgment at two levels. One, the court applying the ERP test on its own to that particular institution and undertaking a reading of the Hadith, the Quran, and whatnot. Okay, and in fact, there was no state action also in Haji Ali Dargah for judicial review to be undertaken in a legitimate fashion. The practice of a particular institution has been called into question as a consequence of a writ petition, which the court believes is sufficient for it to acquire jurisdiction over that particular issue. Honestly, that's a question that the court should have asked itself, whether in the absence of state action, the existence of a practice simpliciter translates to vestation of jurisdiction in the court within the meaning of Article 32 or 226? That's a basic question that the court ought to have answered. That question was never answered. Okay. And this will again, of course, take you back to Narasimha Mali judgment, where the question is whether personal laws and religious laws rise to the level of laws within the meaning of Article 13, which Justice Nariman left completely open-ended in the Triple Talaq judgment when he had the perfect opportunity to address that, despite Mr. Kapil Sibal specifically raising that question. And then the court says we will look at it at an appropriate point of time. I don't know what other appropriate situation could have been presented to the court. This was, according to me, a laddu on a thali, which the court should have taken a bite at. Okay. So the basic point is, as far as Haji Ali Dargah is concerned, we can of course have our own positions on whether the practice itself is right or wrong. That's not, according to me, the question. That's a matter of subjective opinion, and that's a question of individual opinion. The basic question is, the institution that chooses to preside over a certain practice, does it have the constitutional mandate to do so? Second, who gets to escalate the question before the appropriate forum? 3, in the absence of state action, what justifies jurisdiction? 4, is the court otherwise constitutionally mandated or otherwise competent to look at issues of religion, where it decides to perform the role of ecclesiastical bodies, where it looks into laws which apply to different religions? Okay. When the court recognizes that certain matters of policy are exclusively within the domain of the executive, when the court decides to carve out certain benches for, let's say, green benches or certain company benches or whatnot, because it requires a certain amount of expertise or whatever it may be, it is my position that even when it comes to religion, in the absence of expert assistance at the very least, and institutionalized expert assistance, a secular constitutional court neither has the mandate nor the competence to look at issues of religious nature, and certainly not in the absence of state action.
Right. I will reserve my other questions, till the end of the session, in case there is time.
Yeah.
I open the floor for questions. I think Vishal already has a question, so maybe I'll start with Vishal's question, and I can see that the questions are coming in.
Yes.
So the question that Vishal wants to ask is basically, based on your podcast on dharmic principles, and his question basically is that, if we were to build a dharmic state, which kind of duties would it prioritize, and whether enjoyment of rights would be contingent upon fulfillment of such duties?
Now, okay. Vishal, in fact, I've answered this question in another podcast as well, which is to say that when you address the question of dharma, the fact remains that there are multiple schools which have identified what is dharma for each of those schools of thought. Okay. And therefore, to say that dharma itself is a monolith would be ahistoric, and the basic question would be, which pramana or which authority would you rely upon to come out with an acceptable and accepted definition of dharma? That's point number 1. Second, there is a decent chance that a Charvaka or a Nirishwarvadi also subscribes to a certain version of dharma. And someone who believes in the sanctity or the authority of the Vedas also has a specific definition of dharma. Okay. So the point I'm trying to make is that unlike Judeo-Abrahamic traditions, the concept of dharma itself has received diverse treatment from various schools of thought. Therefore, it's a simple question of which particular dispensation subscribes to which school of dharma and which school of thought. Okay. It may not be possible to treat the constitution as the ultimate repository of all forms of dharma, or even reduce one form of dharma as the supreme form of dharma and impose it on everyone. That's something that's never going to happen. And that's perhaps the one reason why I disagree with the imposition of the term religion for Hinduism, at least in the manner in which it is supposed to be understood. For the purposes of constitution, for the purposes of enjoyment of legal rights, it may be treated as religion because the constitution has, resorted to approximation, because English is the language that's being used to describe Indic faiths, and religion doesn't do justice to Indic faiths. And if you were to treat India's civilization as an agglomeration of multiple identities and multiple schools of thought, to basically ask the question, is there one form of dharma or one definition of dharma that can be applied and adopted everywhere? Frankly, I don't think that does justice either to the history of this land or the spirit of this land. And that's one of the reasons that I've been opposing the Uniform Civil Code for multiple reasons. This is one of the reasons, of course. So if you really want to understand what would the dharmic state look like, As opposed to defining dharma, I would actually use a putative definition or a putative identification of characteristics. One, decentralization of religious identity, decentralization of dispensation of justice with respect to religion, and striking a clear distinction between the role that a secular court can perform with respect to religion and what it cannot. Interference must be minimal from the state as far as religious is concerned. Of course, this is subject to the caveat that criminal law, primarily because it happens to be in the realm of public order, shall be the sole preserve of the country, of the sole preserve of the government. There is no doubting that at all. I'm not doing away with that. But in the manner of, let's say, civil laws or personal laws, perhaps the state must avoid this dying need to harmonize, standardize, because that goes against the spirit of this land. We have come together as a country for multiple reasons, but it has not come at the expense of our individual identities. It has not come so at the expense of several localized, contextualized identities, each of which is a product of at the very least 1500 to 2000 years. Therefore, when the Indian state chooses to apply or impose a top-down approach with respect to religious issues or dharmic issues, or even with dharmic issues for that matter, not just necessarily those faith systems that subscribe to the notion of dharma, even those that do not subscribe to the notion of dharma, you must be very, very sensitive to this. Multiple people who have been responsible for the framing of the constitution have clearly said that religion, dharma, whatever you may choose to call it, or faith, largely speaking, is the lifeblood of India. So you choose to touch that particular raw nerve, then you must await certain consequences in one way or the other, because you're asking people to sacrifice something in the pursuit of a unified, homogeneous vision, which I don't think is something that is consistent with the character of this country. Second, what kind of duties would it prioritize, and whether enjoyment of rights would be contingent upon fulfilling such duties? See, the thing is, perhaps you live in an age, or we live in an age, where rights, thanks to the last 60, 70 years, has acquired a certain degree of importance. So to suddenly expect the populace to embrace a completely duty-based discourse may not be possible unless there's a polarizing experience. Usually what changes people's attitude towards rights and duties is that they must go through one nasty or bitter or polarizing experience when they realize, oh, we have to do something. If there is a natural calamity, then you start asking yourself this basic question: expansion of cities at the expense of forests and villages and ecosystems, what are we really doing? That's when you start asking, my rights, if they come at the expense of, let's say, the larger ecosystem, are they worth preserving? Then shouldn't my right effectively give weight to other forms of duties and obligations? And I believe that the discussion from a pure rights-based approach to a balance, and then now we will go back to a duty-based discourse, not for any other reason, but environment is going to be one of the significant drivers in that particular direction, because we'll all realize that at some stage, we will have to sacrifice our needs and perhaps our greeds and whatnot at the expense of a larger issue, at the expense of a larger concern. So if the state really chooses to impose even a duty-based approach, I don't think it's going to work at this stage. Perhaps it needs to be organic. And if the state chooses to even impose it, I would still say the state itself needs a lot of clarity, because there is a decent chance that a duty-based approach makes much more sense in certain areas. A rights-based approach makes sense in other areas. So I'm still saying that there is enough room for, let's say, a kaleidoscopic approach, so to speak, where you need not necessarily approach everything from the point of view of rights, nor do you need to approach everything from the standpoint of duties. Perhaps you can pick and choose your issues, you can pick and choose your battles. The assumption that a dharmic state is primarily duty-based may not be entirely true as well, because the only question is, how do you invert the Hegelian matrix? Whether you're looking at right and therefore duty, or are you looking at duty and therefore right, or is there a middle path which is still possible? Because you still have to be alive to the contemporary situation where you live in, where the moment you say that duties come before rights, you will have to look at the feasibility of it and the acceptability of it in the minds of the population. I don't think that's going to work. You may perhaps want to work with the population a bit more and tell them that rights are fine, rights can be enjoyed, but please be conscious of the excessive exercise of rights to the detriment of others' interests. That, I think, is something that dharmic reorientation can achieve. That's certainly possible. The more we start looking at applying, let's say, a duty-based approach or an obligation-based approach from the standpoint of environment and social responsibility, there is a decent chance that that particular sentiment may percolate in other areas as well. That's my answer. I'm not sure I've answered your entire question, but this is my current position.
Thank you. I have a question from Nikhil Dave, which is in continuation with one of the questions that I had asked you, where he's asking you as to whether the sanctity of the deity and the deity's own rights should take a precedence over, let's say, a caste-based discrimination, or let's say, just to add to it, gender-based discrimination.
Right. So I think I answered that, anticipating that strawman is part of your question. So I've already answered that particular question. If you want to sharpen the question and go up for a follow-up, I'm waiting for it. Let him go and do it. No problem. Nikhil, I've already answered the question in principle. If you want to sharpen that question, please go ahead. No problem. I'll wait for that. In the meantime, we'll take another question. Is the video stuck?
Hello. Yeah. Am I audible?
You're audible. Please. Yes.
Right. So Aditi is asking you that, without subscribing to the natural law theory, the Supreme Court continuously advocates for natural rights.
Right.
Now, do you look at it as a dichotomy? What is the implication?
This could be chota mo badi baat, given that I've been in the Supreme Court for barely 5 years now and in the profession for 11 years. I think there is a tendency to assume that the Supreme Court is thinking as an institution. It is not. Okay. There are as many Supreme Courts as there are benches in the Supreme Court. Okay. And the fact remains that no particular judgment, so to speak, is trying to establish a narrative which is consistent with the previous judgments. And if we think that in every case the Supreme Court is asking itself, am I being consistent with the positions that I've taken in the past? Frankly speaking, that really is not how I have seen the Supreme Court function. Rarely have I seen the Supreme Court trying to come out as a consistent institution on matters of rights, on matters of theories, on matters of ideological positions. And naturally so, because that particular institution, like any other institution, has a mix of a lot of people with varying positions. And therefore, as much as we try to objectivize the standards of dispensation of justice, particularly in the arena of constitutional law, it is bound to be rife with a lot of subjectivity and inconsistency, for the simple reason that there are multiple pulls and pushes and tugs of varying natures and for varying reasons, not all of which can be spelled out. Therefore, all I can say is this is perhaps, I'm sure the question is fantastic from the standpoint of someone who's perhaps not entered practice, but the moment you enter practice and after a few years you realize, to a very large extent, most of these things are ad hoc. Okay, and the rest of us are trying to make sense of what the institution is doing and the direction in which the institution is going. But frankly, the institution may end up asking us, what's the point? I never thought of these things. So I think most analysis of Supreme Court judgments is ex post facto and an afterthought, hindsight appreciation of what the Supreme Court would have thought according to us. But frankly, anyone who stood there and argued will tell you, perhaps these are not even the remotest of considerations on the radar of the Supreme Court when a judgment is being passed. Okay, so I think the Supreme Court treats it like, let's say, to use a cricket parlance, play it as per the ball, and it's not even looking at 5 overs or 10 overs down the line. Okay, so this is something that I've tried to tell, and I understand that it dissuades a lot of academic analysis. I'm not saying no to it. Perhaps you can look at how the Supreme Court has been inconsistent as opposed to looking at how the Supreme Court has tried to be consistent in favor. The Supreme Court doesn't try to be consistent, is my humble opinion.
Already in the chat box, there is substantial amount of prodding towards moving away from matters of religion. But before I do so, there are just a couple of questions. I think some of these questions which are being asked have already been addressed. So okay. I'm not repeating them, but there are some specific questions. In fact, 2 specific issues that the students would like you to address. Yes, one please. About your opposition to the Uniform Civil Code. I think you have partly addressed it already. That the state has business in formulating codes that bind everybody homogeneously. But if there is anything else that you would like to add to it, and the second is your opinions about the fundamental right to pray in Ram Janmabhoomi and its implications over, the government's control over majority of Hindu temples and the safe, free Hindu temples movement.
So I think I've said this before. Until 2011, I was a blind supporter of the Uniform Civil Code, and I would underscore the word blind. That's the operative word. Okay, because I took that as perhaps the holy grail towards which the entire society should move. But as they say, I read a bit more. I understood how the Indian state has operated, and I was frankly aghast at this particular thing still being touted as the panacea to all our ills when it comes to the fault lines in the society and whatnot. I don't see how the Uniform Civil Code will end up unifying the society. In fact, it comes at a serious price, which I don't think I'm willing to pay, nor am I interested in paying as well. So if you look at the Succession Act and the 4 Hindu legislations that were introduced by Sri Nehru, along with the active and able assistance of Sri Dr. Ambedkar, 2 things at the very least happen. One, it's the Mitakshara school of thought that has been effectively applied to the rest of the country, to the entire country. There is no historic justification for this at all, at all. Every right that you guarantee under 25 and 26 and 29 and 30, perhaps 29, has been completely eviscerated, according to me, by this bill, by this particular act. And the reason that was ostensibly given for the passing of these Hindu bills was to basically say, you see, this is such a hodgepodge of diverse practices with so many rules. How do we govern this country? How do we do this? I'm sorry, the moment you start looking at this country as a country, you will suffer. You treat this as a subcontinent which masquerades as a country. You think of this as a continent that masquerades as a country. Look at the number of languages. If you are comfortable with having any number of languages over 20 for the purposes of administration across the country, are you telling me that you have a problem with laws as well? How can that be the case? And you have Dayabhaga and Mitakshara, which are the only 2 things that are taught in law school. Out of that, only 1 is mainstreamed as part of this particular legislation. And that comes at the serious ways of life which is protected by the Constitution, by other provisions. Any justification that is given by the state only translates to administrative convenience. If you do not know how to manage me, that is not a problem which is with the society. That is a problem with you, because you don't know how to govern me. You don't know how to administer, dispense justice to me. Okay, that can't be the justification for a uniform civil code, for God's sakes. And the funny part is, I've given this example even before. One, if you treat that this country is not a monolith, and let me go to the most extreme statement possible and provoke a few sentiments. Assume for a moment that this country were 100% Hindu. Even if it's 100% Hindu, even then a uniform civil code cannot apply. And a uniform civil code wouldn't make sense even if the country were 100% Hindu, because Hindus themselves have a lot of diversity, and the diversity is not a platitude for the purposes of writing an academic paper or to sing hymns in praise of Bharat's civilizational diversity or to say this is unity in diversity. Diversity is a fact. Diversity is a way of life. Diversity is a reality. It's a lived experience for every community, which translates to received traditions and customs from its ancestors. Okay? And it is nobody's business, and certainly not the state's business, to say, don't follow the path of your ancestors. You give me a better answer. You give me a better option. You give me a better solution. Are you in a position to tell me that the homogenization of all these laws has ultimately led to strengthening of the family system, which is the bedrock of the Indian society? No, the answer is a no. You have not done any of that. None of your stated goals have been achieved. So what is it that you wanted to achieve? Itna paperwork kaun karega? Itne establishments kaun establish karega? In logo kaun manage karega? That is not the way you're supposed to approach a society like Bharat. And the moment you do so, you're no different from the white man who had a problem with the sheer explosion of diversity, which he had never come across before. Okay? So there is a policy continuum between the Indian state and the British state on that particular aspect, or the British Indian state, where diversity is a problem. It's not something that is to be celebrated. It is not something that is to be pampered or indulged or encouraged. It is to be quelled, but it is to be sung off, and you're supposed to praise it for the sake of public consumption. But when it comes to practice, you kill it on a daily basis. So in principle, I have a problem when somebody again chooses to come out of the Uniform Civil Code, because the Indian state, frankly, is not a secular state, has not been a secular state in any sense of the word. And it has been extremely politically convenient and expedient in its application of secularism, and therefore I don't trust it to do justice to the rights of any community, and certainly not the Hindu community. There, I've said it. because the experience and the track record of the Indian state with respect to treatment of these rights has been shoddy, abysmal, and downright poor. So I don't think the Uniform Civil Code has been given the necessary justification, the necessary legs and spine and flesh and blood for anybody to say, this is the reason why I'll hold this placard and say, this is the cure to all your ills. I don't think that's how it works. I don't think, and the funny part is, those organizations, be it political and cultural, which constantly speak of Uniform Civil Code, must only read the works of their founding fathers and their founders, so to speak. None of them has supported this. Shyama Prasad Mukherjee is against the Uniform Civil Code. In fact, he makes a statement bluntly during the course of arguments in the Hindu bill that if you really want to encourage people to adopt a Uniform Civil Code or a normalized civil code or a standardized code, make it optional. And those who want to make that shift or that switch will do it. But if it's your point that the orthodox person or the traditionalist must not impose his views on the person who wants to be progressive, liberal, secular, whatever it may be, it's a two-way street. The secular, liberal, unorthodox person also does not have the right to impose his views on the orthodox person. To each his own. Therefore, make it optional. Those who want to continue to live by the old laws will continue to, and those who want to live by the new laws will continue to. Israel is a standing example of that. You have separate courts for Muslims, Sharia courts. You have Druze courts. You have Christian courts. You have rabbinic courts. So decentralization of personal laws is the first mandate if you want to foster and if you want to encourage diversity in a fundamentally diverse society. And the Indian state constantly makes the mistake of treating itself as a nation state. You're not a nation state, you're a civilization state, which means the respect for diversity and the practical treatment of diversity will be different and vastly different from a nation state, because a nation state has perhaps one or two markers which bind people as a nation. But if it's a civilization, by default, there are multiple identities, multiple cultures, sub-identities and subcultures, each of which has a legitimate right to exist. If you're telling me the only reason that we must give up each of those identities is for India to survive as a unit, then you've failed to wrap your heads around the concept of a civilization. A civilizational state stitches itself together and keeps its diversity alive, doesn't kill diversity at the altar of unity. That is something that I don't think the Indian state has managed to wrap its head around, unfortunately, even after 73 years.
On this point, that your argument that we are unnecessarily trying to secularize the whole process.
Right.
Would you like to address this question which Abhinav has raised? That this idea of the state controlling. In fact, Anshuman also has referred to this. This point: the state controlling and state managing the affairs of temples.
Right.
One, is it antithetical to the whole notion of secularism as we perceive it?
Right.
Second, when the state is mismanaging it,
right,
royally mismanaging it, as it says,
right,
is there a way out?
See, the interesting part about introducing secularism in this argument, and as someone who's dealt with these issues first, and let me tell you how it bubbles and it simmers with inconsistencies and hypocrisy on the part of the state. Let me explain how. Okay, so here's what the state does. With respect to Hindu religious institutions, the state takes the position: if I am not there, you guys will fight amongst each other because you have caste issues. Okay, that's what the state says. Now, when the state enters a certain institution, the state is supposed to give a written administrative order justifying its march-in rights. That's the basic principle. To explain why it enters, there is not a single written order across the length and breadth of the country where the court has cited caste-related issues for exercising its march-in rights to take over the administration, rather where the state has given a written order to that effect. Second, the state has given orders with respect to fiscal mismanagement, financial mismanagement. Some of these orders are as old as 50 or 60 years. And therefore, the state is saying in the last 50 to 60 years, it has not been able to set the house in order. You've been sitting in that institution for 50 to 60 years. Had this been a company, no official liquidator or no person who's appointed by the state to run the affairs of the company on a temporary basis can ever sit permanently or for an unreasonable period under the pretext of setting the, let's say, the company's house in order. Okay. But somehow when it comes to a religious institution, an avowedly, ostensibly secular state says that it has the right to sit there for 70, 73 years. Okay. 3, the justification that is sometimes given by geniuses is that, no, under traditional Hindu states, Hindu kings used to manage temples. And therefore, what is wrong if the Indian state manages temples? Fine, then declare India a Hindu state. Are you willing to do that? Are you running India in accordance with Hindu principles? Are you running India in accordance with dharmic principles? Which Shastra are you abiding by? Which Rajniti are you abiding by? Please give me the answer. First of all, it's a myth to say that kings used to run temples. No, kings never used to run temples. The moment a temple is constructed, it is dedicated to the community. And subsequently, the only dignity or the only liberty or let's say privilege that the king enjoys is that of primary service, and which is like the moment you look at Odisha, what is the primary service you're looking at? He's the first person to sweep before the Rath Yatra. Okay? And that is the extent of humility, not the VVIP darshans that these people expect. Okay? So, frankly speaking, every notion of militant secularism, every notion of civilizational secularism, and every notion of non-secular administration, all of these have been completely violated in bits and pieces. And what you have today is an expedient, convenient notion which is used to justify the continued entrenchment of the state in these institutions so that they can liberally dip their hands into the coffers of the temple and use it for other purposes except for benefiting the community. I dare say this bluntly. If tax money cannot be used for religious purposes, religious money cannot be used for secular purposes without the consent of the community, period. There cannot be any kind of compromise on this particular aspect. In fact, if I would say it's a greater harm that is caused when the community's consent is either taken for granted or completely dismissed when you choose to use its resources for issues and aspects which it has never given consent for, where it is never even consulted. Multiple states, especially in the north, including Uttar Pradesh, the charity commissioner decides where the money goes entirely. There is no say of the community at all. Okay? And these are central legislations that are amended and applied to some of these states. And in some states, you have state legislations which mandate this. Administration of major temples is completely appointed by the state, be it Jagannath Puri under Section 5 of the SGTA Act of 1955 or Section 96 of the Andhra Pradesh HRC Act of 1987, where that specific chapter is dedicated to Tirumala Tirupati Devasthanam. Every appointee is appointed by the state. If you're appointed by the state, how can you claim to have any kind of autonomy or independence? If the state can't appoint judges for the simple reason that judiciary loses its independence and autonomy, how can the temple remain autonomous and free if the state is appointing its administrators? Autonomy and independence as concepts cannot be different for two different institutions. And it can't be your case that judicial autonomy is more important and religious autonomy is less important. I have specific provisions in the constitution which envisage my autonomy, 26 specifically. Therefore, the only right of entry that you get is for a very limited right under 25(2)(a), which is for regulation or restriction. And regulation or restriction of what? Financial, political, economic, or other secular activity which is associated with the religious practice. This is the specific phrase which has received brilliant treatment from three judgments. 1954 Shigurmat judgment, 1965 ADG Pandarasandari judgment, then Justice B.S. Chauhan and Justice Bobde as part of the Chidambaram Temple judgment on 6th of January 2015, Dr. Subramania Swamy versus State of Tamil Nadu. Okay, where the court says, if ultimately it speaks of regulation or restriction, how did it ever translate to supersession of administration and takeover of administration? When did this become the case? Okay, and the worst part is even religious activities are dictated. When can you conduct the archana? Whether you can conduct this particular puja or not? What kind of resources are supposed to be employed for a particular activity? Who on earth are you to dictate any of this? You're not supposed to be doing this. If you're a secular state, then get out. Even if you're not a secular state, then stay in accordance with the rules that are established for the purposes of that particular temple. If you put yourself in the shoes of the king has to surrender in front of the temple. Do that first and then we'll talk. Right? So, according to me, it's been a position of convenience, rank opportunism, and it smacks of hypocrisy. Honestly, there is no fairness or reasonableness in which the state conducts itself. And the argument is, if we leave, there won't be any corruption. The Indian state is accusing somebody else of corruption. Mighty rich of the Indian state to do that. Okay? You can't seem to keep yourself clean when it comes to defense deals. You're really accusing somebody else of corruption. Come on. Doesn't make sense at all. And second, it's the same stupid reason that the British man gives the Indians. If we leave, who will govern the country? I don't see how we have managed to inherit all these arguments from the white man. It really makes no sense. Okay? And we seem to be using that specifically with respect to indigenous institutions in the worst of manners possible. I'll give you this example. There are at least 5 legislations which have been applied to major temples in the south. Each of those legislations has been renewed decade after decade to say for better management and proper management. What have we been doing for a decade? What have we been doing for 20 years, 30 years? I'd like to see the audit records. And the worst part is the state gets a cut of 13 to 18%. And the state will undertake that audit to say there is a problem, therefore I must get in. So aren't you creating a revenue stream for yourself? And aren't you therefore creating a problem where none exists, or perhaps that doesn't require your presence? Ideally, there should be an external audit. So the department which ultimately has the power to take over a certain institution is the department that undertakes an audit. And lo and behold, every time it undertakes an audit, there is always a problem. There is never an audit which is given a clean chit. That's really surprising. So I do believe that the Indian state, as I said, is far from any established or accepted notion of secularism. It is as unsecular as it gets.
I think we have a fair amount of articulation of your views on religion.
Right.
Already, I am noticing that there are questions coming on, CAA. So would you like to briefly touch on, CAA and why you think, as in, is your support to the CAA also premised on the fact that, this whole idea of secularism that the Constitution or the opponents of CAA tends to put forward as an opposition plan? Do you want to, essentially question that?
See, in fact, let me actually clarify a few things. Thanks for asking this question because it's very important. There have been, in fact, here's what happened. I think the Quint wanted me to write on CAA. Okay, they reached out to me. And years ago, I think in 2015 or so, I wrote one piece for them, perhaps on a trademark issue, and after that, they kept asking me to write. I chose not to write because the readership doesn't relate to nuance, because they want everything in 350 words or 400 words, and therefore I refused to write. And subsequently, I started taking positions on a lot of issues, from the Rohingya immigration issue to the CAA to NRC and everything under the sun. And when I stopped writing is when the Quint started writing against me. Okay. And why do I make this point? What is the relevance to this? To this particular topic is in one particular article where it cites another colleague of mine from the fraternity. Of course, I'm not sure I can call him a friend, but Suvrit Parthasarathi, who practices before the Madras High Court. Juxtaposing his position, my position, Quint says, here are the positions of the opponents, and then here are the positions of the supporters of the government. Okay, so anybody who supports the CA or the NRC is a stooge of the government or the supporter of the government. Little did the geniuses even realize that I have a serious problem with the Uniform Civil Code, which also seems to be a pet peeve of the government. Okay, so it's an issue-based approach. So let me be very, very blunt. Regardless of which dispensation would have brought about the CA, I would have supported it lock, stock, and barrel with certain tweaks and changes, of course. But in principle, I support the CAA. I will stand by it no matter what the opposition, for the simple reason that there is a constitutional obligation, there is a civilizational obligation for people who are being butchered for their adherence to Indic faith systems by countries in the vicinity who avowedly have a religious character and who are using their religious character, unfortunately, to justify the cleansing of other communities, period. India does not owe an obligation to every community across the world. India primarily owes an obligation to those who belong to its civilizational faiths. I'm saying this categorically, and I will support this with specific arguments from the Constituent Assembly debates, where the discussion revolves around Hindus and Sikhs only, not anybody else. Okay? The Constituent Assembly debate makes it very, very clear that this is the position. And to use secularism here, secularism is not an argument on the basis of which this particular issue can be tested for two reasons. One, the basics of vestation of citizenship under the Citizenship Act of 1955 are not being changed by the Amendment Act. No provision that speaks of naturalization, no provision that speaks of, let's say, citizenship by birth has ever been affected. The absence of a refugee law is the only reason that a specific targeted surgical amendment has been undertaken to accommodate a specific class of people on the basis of an identified metric from specific regions or specific countries. The argument of under-inclusion is as stupid and as dumb as it gets. Let me be very, very blunt on that, because that argument says if the refugee law is incapable of accommodating persecuted groups from across the country and across the world, from across the world, it suffers from under-inclusion. As a sovereign country, you're basically saying that this country doesn't even have the right to decide who can enter its borders and who cannot. It goes against at least two judgments of the Delhi High Court and one judgment of the Supreme Court in the context of the Citizenship Act, where it identifies that those specific entries that deal with ingress and egress from India's borders are exclusively within the domain of the central government, primarily because the central government is seen as the one sovereign entity which is supposed to protect the borders of this country. The only limitation is Article 355, where the government cannot invite people at the expense of the demographic composition or at the expense of territorial borders, and that's the specific provision that was cited in the context of Assam. In the Assam Samyukta Mahasangh case, where the court said that the constitutionality of the special provision, which is Section 6A of the Citizenship Act, which speaks of special provisions for Assam, must be tested on the anvils of whether it violates the Assam Accord as well as Article 355. Okay, so secularism as an argument, frankly, is dumb. It has no constitutional basis in the context of this particular act. There is no argument to be made as far as under-inclusion is concerned. The only strong argument which according to me can be asked is, what is the significance of this cutoff date? If your goal is to try and address those people who are persecuted because of their religion by people because of their religion, and that is their position, and the world has recognized it, why are you limiting their access only to the cutoff date of 31st of December 2014? That's the only question that needs to be asked. Second, none of these people have actually even read that the actual benefit that is given is in the third schedule of the act, which has been amended to the limited extent of saying, as opposed to 12 years of domestic existence in India, you have to reside in India for 5 years in order for you to have an access to an accelerated citizenship. That is the only limited benefit. If India had limited its doors and its gates and its access to citizenship to only these groups from these countries, and had closed all other existing avenues for citizenship, then perhaps the Citizenship Act would have been open to a serious challenge, wherein you have closed your doors on grounds of nationalization, on grounds of everything else. Okay? But all the traditional avenues, which are as open to other communities from the very same 3 countries and other communities from the rest of the world, have been left untouched. And a specific accelerated pathway or gateway has been created for these specific communities, considering the nasty, inhuman situation that they live in. And that is being accused of under-inclusion, over-inclusion. I must say, this is over-esotericization of an issue at the expense of logic, at the expense of practicality, and they have clearly no idea as to what the actual implication of this Citizenship Amendment Act is. In fact, I had one trained constitutional lawyer make the statement, and what is the statement? And I'll tell you. I hope people have read this 3-page document called the Citizenship Amendment Act. There is a definition of an illegal migrant under the Citizenship Act. That definition has been provided with a certain proviso to ensure that these members of the 6 communities coming from these 3 countries are exempted from the definition of an illegal migrant. Okay? I was told that they are being granted automatic citizenship as a consequence of the proviso, and they have been, and all proceedings under the Foreigners Act for illegal migration against them shall stand abated as a consequence of the proviso. The proviso is to a definition clause. The satisfaction of a proviso under a definition clause is subject to other provisions of the Act, which is Section 6 and Section 5 and 6A of the Citizenship Act. So some of these people actually made the argument that the moment the proviso was added, they stopped being illegal migrants and they started being citizens. And these are trained people who practice constitutional law day in and day out. And I had to ask myself, which provision or which concept of, or which precept of constitutional interpretation says that a statute with respect to citizenship must be interpreted in such a nasty fashion? I don't understand this. If the section that deals with vestation of citizenship makes it very clear that subject to fulfillment of conditions, you shall be given a citizenship certificate, and only upon that certificate being given, the proviso becomes, the proviso is triggered, and only when the proviso is triggered, you come under the basket of illegal migrant. Where is the concept of automatic citizenship? So this is the extent to which even trained people wearing the black and white have read something which is written in black and white. Okay, I'm perfectly fine with somebody even making the argument that perhaps the government completely goofed up on its PR strategy, completely goofed up in addressing legitimate concerns, whether religious minorities of this country shall stand excluded as a consequence of CAA. So the discussion and everything starts on the CAA, but when a concern is, and when you probe as to what the true concern is, the concern is, oh, now they'll bring in the NRC. And the procedure for NRC, the mechanism for NRC has been around since 2003, by the way. Okay, which has never been the subject of challenge. Go ahead, please challenge it, no problem. But it's your case today that NRC, which has been undertaken with respect to Assam and is statutorily provided for the rest of the country and has been in the statute book for over 15 years, at least 15 years, I'd say. You're looking at 17 years. Suddenly, you seem to have a problem with it because you think that no CAA se argument abhi NRC ki aur ja raha hai. Honestly, the pitfalls are too many. The connections are practically untenable. The other argument that was even made, and I'm really not waiting for questions here because I've heard almost everything. Most of these questions I've already heard. Okay, and I haven't seen too many questions which are, let's say, imaginative and which come out of the box. What are the questions that are being asked? Assume for a moment that a Muslim in this particular country, as a consequence of a national NRC, gets excluded and a Hindu also gets excluded. The Hindu will get the benefit of the CA, whereas the Muslim will not get the benefit of the CA. That's the question that's being put over and over again. I said, you really have to be someone who is unlettered and uninformed to make this particular point, for the simple reason that anyone who is the beneficiary of the CA must necessarily show antecedents from these three countries in the form of some documentation. Are you saying that someone who settled in Coimbatore or Kadalur or Tenkasi or Tirunelveli or Siliguri or some other place will automatically be able to conjure a document which shows that he is the Bashinda of Pakistan, Afghanistan or Bangladesh without there being any trace at all? How can he suddenly conjure the document? The only way he can do that is through fabrication. He has to manufacture such a document. Okay. Look at the kind of unreasonable questions that are being raised. Fine. Okay, let me go a step further. Assume for a moment that this is truly the concern. How do you know for a fact that everyone who comes to this country claiming to be a refugee is truly a refugee and is not a spy? Those arguments which you apply to those people who are the beneficiaries of the CA, you will have to automatically apply to everyone who wants to enter this country either as a refugee or for some other reason. How do you know for a fact that any singer who's come from Pakistan is not a stooge of the ISI? Have you decided that? I mean, how do you know that for a fact? We don't know, right? So those arguments which apply to everyone who are non-beneficiary of CA are specifically applied only with respect to CA to question CA. It makes no sense. So concerns which are equally valid to non-beneficiaries of CA as well as to beneficiaries of CA do not point anything particularly wrong with the CA is what I'm trying to say. You have to make a case with respect to the CA which is extraordinary and which does not otherwise apply to non-beneficiaries of the CA. That's the straightforward answer. All concerns with respect to documentation, all concerns with respect to persecution, all concerns with respect to refugeeship equally apply to those people who are refugees but who are non-beneficiaries of the CA. Then what is your answer? How do you verify whether each of them has been persecuted? How do you not know that somebody is pushing them from that part of the country? How do you not know that a certain document or a certain situation has been created to push them into this country? Europe is facing the consequence of this. So I'm making the very clear statement and I'm taking the categorical position. At the very least, please read up the act and dig deep if you really want to present a case which doesn't embarrass you when you want to challenge the CA. Otherwise, most of these questions are embarrassing, at least when they come from trained lawyers or when they come from law students, because the basic expectation is that the level of rigor and depth is much better than those people who are not trained in the law. I've seen very few people actually raise a good question. The only decent question that I've seen so far is the question with respect to the cutoff date. That is the only limited question which needs to be addressed. Beyond that, neither is secularism an answer, nor is under-inclusion an answer. I think Professor Sen's video is stuck.
Essentially deal with inclusion. So, hello?
Yes.
Can you hear me?
Yes, I can.
Yeah. So I think a couple of questions in the chat box are essentially dealing with under-inclusion. So since we've already addressed it, yes. I think that, we don't need to repeat them. Right. Is there anybody else who would like to ask any questions with respect to, the issues of religion or NRC, CAA, etc.? Essentially issues of citizenship. Okay, Anshuman has a question on NRC. What are the main issues you identify with the manner NRC exercise was carried out in Assam? Do you think it could be scaled up to be implemented in India?
Frankly,
now I think it's more of a executive policy-based question. So if you have an answer to it.
See, I've identified based on my limited experience on what I think went wrong in Assam, and I've said this before, which is existing reports of even experts who have served in that area show that for a period of 15 years, organized rackets for forgery of documents and for legalization of illegal migrants was in place, and it continues to be in place. And therefore, NRC Assam was doomed to fail at the word go at the outset. It achieved nothing. And as long as you do not have a separate task force to address illegal migration, you will continue to be handicapped, and you will continue to find yourself short of resources, dedicated resources to address this particular issue. The funny part is, very few people who've dealt with this issue have highlighted the solutions identified by the Law Commission under Justice Jeevan Reddy as part of the 175th Law Commission report. In at least 5 speeches and 5 talks, I've done to death this particular report, and still people have not read it. Please read it. It's a fantastic report which does multiple things. One, it asks for setting up of a separate task force to deal with the issue of illegal migration. 2, it asks for ramping up the number of foreigners tribunals for the purposes of deportation. 3, it also says that in the event that the country from where they are illegally migrating is not in a position to accept them, it seems to be the case with Bangladesh, which refuses to accept that there are people coming from there. Then what you do is that as opposed to housing them in cages and shelters, you take away their right to vote, and you also take away their right to own immovable property, and they get work permits otherwise, so that they can continue to live in this country with dignity. And you put them on notice that the standards of law and order which are supposed to be observed by you are higher because you do not belong to this particular country. You're not a citizen of this country. So the moment you violate any of the rules with respect to work permits, you shall be sent out of this country. You shall be deported. We will throw you out of the borders. After that, it's your headache. The funny part is the enhanced rules of observance which the government has actually prescribed for holders of the OCI card as part of the CAA. It should be doing that with respect to illegal migrants. Those people who hold the OCI card today have a specific obligation that if they violate even one rule, any rule for that matter, it can be even a traffic signal, God knows what it can be, that immediately triggers the loss of the OCI card. Okay? If that is the enhanced obligation that you've imposed on people who hold OCI cards, that means they're otherwise of Indian origin legitimately, then you must also consider similar options for others. Otherwise, what's going to happen? You will have a lot of people shrieking and shouting from the rooftops that the manner in which that they're being held and treated in these camps, internment camps or whatever camps, is inhuman. You can't even dismiss it because you know for a fact that in Indian conditions, you don't necessarily expect them to be treated properly. You don't expect them to be treated with dignity. That's a legitimate concern. But so is equally legitimate the concern of the Indian society and the Indian state, so to speak, that I am in a hostile environment. There is written, documented literature that clearly shows that more than one ambassador and more than one head of, let's say, the other country has clearly said that the only way we can survive is by creating a Lebensraum, a free living space in India. And there is a greater Bangladesh concept that's being touted over and over again, that's been spoken of by the founders of Bangladesh, that's been spoken of by subsequent leaders. If that is clearly an expressed intention, a stated intention, to say that the rest of us are supposed to turn a deaf eye and a blind ear and to live as if everything is hunky-dory and as if we are a United States which is living next to a Canada and a Mexico, frankly, no. You're not living in that particular continent. You're living in perhaps the most sensitive, volatile region of the world. So to look at these issues purely from the standpoint of human rights or purely from the standpoint of the Constitution is to turn a blind eye to the history which precedes this entire sequence. From the 1950s, Assam has been facing a certain instance. Please go and try and accuse any Assamese of xenophobia. He'll ask you, do you really know what you're talking about? He's bound to ask you this question, that we are the people who've borne the brunt of this illegal migration for over 50 years, over 60 years. In fact, it goes back to the partition of Bengal in 1905. When East Bengal and West Bengal were created. And then there was a forced migration of a specific demographic so that you can have a labor workforce for the tea estates which were being cultivated then. And then it translated to a political movement around the time that the concept of Pakistan started emerging on the horizon of Indian politics. All of this needs to be looked at together. To say, no, please don't look at it that way. It's xenophobic or it's inhuman. It's unsecular. History and facts don't care for secularism. They are what they are. If you're not in a position to buy them and you have a weak stomach, there's nothing that can be done about it. And the worst part is when you approach these issues purely from the standpoint of constitutional law, then you forget that constitution cannot be ignorant of history, cannot be oblivious to history. It's a product of history in itself. And therefore, to interpret the constitution in a way which preserves the constitution and destroys the sovereign republic which the constitution is supposed to preserve and protect makes very little sense. Precisely why I'm specifically saying that the document must be seen as a civilizational document. It can't be seen as an ahistoric document.
I think we are coming to the end of the session.
Yes.
If there are no other questions, I would like to just, okay, Aniket has a question. Wouldn't decentralization to state and local levels of religious organizations may lead to stifling of dissent in religious community at local level, as there may not exist viable bodies or forums to ask for reform at smaller levels? So,
the converse is centralization means the government listens only to the strongest of bodies with the maximum of numbers. I don't see centralization actually leading to a situation where the government is actually responding to the weakest of minorities or the weakest of people. No, the government responds to people who pelt stones or people who are in a position to effectively block roads or people who ultimately decide to bring an entire state to a standstill. That is how the Indian state has responded. Anybody who has the numbers can effectively bring the entire state to a grinding halt and hold the society, the country to ransom and at a hostage. So frankly, I would prefer decentralization much more than centralization, because centralization is the government kowtowing to someone who has the numbers or someone who has the ability to lobby or someone who has the ability to grease the machinery. That's how it is worked. At least when it comes to decentralization, the community will find a balance. The community will at least arrive at some kind of a solution because they have to live together. The politician has a vested interest in creating one situation or the other. He's not necessarily looking for social cohesion. He's not looking out for harmony. But the community will certainly look out for harmony more than the politician, because the community has to live with each other. Whether you like it or not, the politician is going to live in his bungalow. He's surrounded by security guards. But you can't be in a constant state of strife with your neighbors, with the people who live in your society. You will have to find a way to work with them out. Therefore, I am merely saying that sometimes perhaps we give too little credit for the society's ability to work out solutions. We believe that a traffic signal is necessary, and in the absence of a policeman, everybody is bound to violate it. I'm saying sometimes that's not how it works. So maybe we start putting some more faith in let's say traditional dispute resolution structures where societies ultimately manage to resolve their problems. I'm not saying, therefore, let the state vacate and give a free pass to every fellow who wants to come out with some kind of a panchayat or whatever it is. I'm merely saying, let there be a reasonable balance struck between dependence on the state for resolution of community disputes and communities evolving a way of addressing their problems. Today, in a democracy, the state is an actor with a vested interest. And as long as we function under the naive impression that the state is some academic, let's say, holy creature, it is not. It has never been, it will never be. So communities have to effectively find a way to resolve their problems. And unfortunately, that won't happen unless and until there is a discussion which is open. But if the discussion starts with hurling ad hominem allegations of labels and unsecular and whatnot, there is no scope for any, let's say, common ground to be found. So it starts with a conversation, it starts with a dialogue, keep the politician out, start talking, then perhaps you'll actually find a common ground. When you realize that things have come to a pass where you cannot resolve issues without resorting to violence, that's the only time the state enters to prevent violence. Until then, the communities must talk to each other.
I have one last question from Abhinav. We were talking about the polyvocal nature of the Indian Supreme Court. So do you think, Abhinav's third question, so do you think the fact that most of our rights are a product of judicial innovation a contributory factor to the non-uniformity of judicial decisions?
Okay, Abhinav's third question. Let me just see how he has framed it to see if I missed it. Yes, our constitutional jurisprudence, especially fundamental rights and judicial appointment today, is largely untethered from both the intentions of the Constituent Assembly and the bare text of the Constitution. Ignoring for the sake of argument judicial reinvention of Article 21, there is no way one can possibly derive a right to privacy agreement from the text of Article. Do you think that must be? Yes, correct. So one of the things that the judiciary did in the 3 judges' judgments in trying to justify the collegium system was that it came out with the doctrine of necessity. Okay. Now the doctrine, according to me, is a blank check. It's a kura kagaz. Jo bhi likhna hai, likh lo usme. Okay. Now the doctrine of necessity rears its head at the most. Let's say it's not so innocuous of instances. Okay. So I do believe that to lay the blame entirely at the judiciary is also not right for a different reason. And I'm not saying this to hedge my position. I will say what my position is regardless of what the consequence. The point I'm making is when you have the executive and the legislature, especially at the peak of its, let's say, corruption. There's a reason why the 70s and 80s movies are, they have politicians as the villains, the corrupt politician, the Babu as the villain. There's a reason because it's actually reflecting what has happened. Then your only option of last resort, where you choose to knock the doors of an institution to say, give me some succor and help me out, is the judiciary. And when that has happened, society, thanks to its frustration and desperation, has put all its eggs in the judicial basket. Okay, and that position has continued because power effectively, regardless of whichever organization or institution it may be, has its own heady, let's say, impact. Okay, so when the society chooses to surrender all its, let's say, rights and all decision-making powers, not to the legislature, not to the executive, and goes to the judiciary, that position has continued since then. So it's like an unreserved compartment in an Indian train. Jo baith gaya, so baith gaya, uske baad nahi uthega. Okay, so after that, it's going to be difficult to ask a person to vacate the position, no matter how respectfully you ask and no matter how you ask. Then the only option is then people start asking certain questions to basically say, pray tell me, where are you deriving all these powers from? Because on the one hand, you're asking us to respect constitutional morality. How is it constitutionally moral for you to hold all these powers? That's the basic question. Okay, and unfortunately, this question is being asked of a certain forum which wields the Contempt of Courts Act, okay, and which also has no accountability from the outside. There may be internal accountability, but there is no accountability from the outside. And you have no right of direct audience unless and until there is a case in front of the court on that particular issue. So you can make a representation to the politician, you can make a representation to the cabinet, you can make a representation to every elected representative, but you can't make a representation to any member of the judiciary or to the judiciary itself. None of those, let's say, mechanisms have any value. So the one thing that perhaps it's time to consider is Justice Bhagwati and Justice Iyer effectively said, let's start epistolary jurisprudence. That is, we will receive letters against the state and take cognizance of those causes of action to give rise to public interest litigation. I'm saying no, go a step further. Please take cognizance of letters against the third member of the state as well. Okay. So if you're happy to take letters with respect to the executive and the legislature, I don't see why you can't take cognizance of letters with respect to others. Okay. Surely one organ cannot be an exception to one form of jurisdiction. Okay. So आज की सभा यहीं पे खत्म करते हैं. प्रवचन हो गया. जय हिंद.
I think it's probably, you have hit the nail on its head, and it's the right point to end today's discussion. I'm sure the IDG will ensure that the transcript of your observations at least does not reach some recently retired members of the higher judiciary.
I would now like to invite Hardik to deliver a small vote of thanks before we conclude.
On behalf of the Informal Discussion Group, I express my sincere gratitude to Mr. J. Sai Deepak for sparing his valuable time to be with us this evening. We are truly privileged to have interacted with you, sir. I hope each one of us is taking something from what has been a very insightful session. Sir, we are extremely honored that you retain for moderating the session, our committee members and all other participants who joined in and asked such wonderful questions, making this session a success. Thank you so much, sir.
Thank you. I thoroughly relished and enjoyed the experience, and I hope to work with some of you guys someday. All the very best.
Thank you, sir.